Okay, on the record in the matter of the people of the state of Michigan versus Ron Trino. This is file number 24-00171 SM. Appearance, please.
Morning, Your Honor. Case Mark Darian appearing on behalf of the people. First, making a motion to practice under Michigan Court Rule number 8.120.
Motion granted.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Trevino, who is appearing from the Ingham County Jail over Polycom today.
Okay, Mr. Trevino, today was the date set for sentencing. I do have a pre-sentence report recommendation that was prepared back on September 11th. Did you get a copy of that, Counsel?
Yes, we did.
Okay, any reason to make corrections, updates, or deletions?
No, we do not have any corrections to the report.
Okay, you can make allocution.
Thank you, Your Honor. Your Honor, Mr. Trevino has currently served 56 days on this case. However, when I spoke with him, he still wants to do a term of probation to try to earn the 7411 status that he was seeking at the time of his plea. He's certainly willing to do any type of drug class that the court asks of him. He was working full-time at Ento Chef prior to his incarceration on this matter, and he's certainly willing to, or he believes he's going to be able to go back to that job upon his release. So, Your Honor, I would ask that the court follow the recommendation here and sentence him to a term of probation. But with the 7411 status, this was his first drug offense, at least what I thought.
Your client wish to make a statement.
Mr. Trevino, it's your turn to make a statement if you like.
Yes, I would just like to apologize for the last time we spoke. I actually under 6 months and just going through things. My grandfather passed. It's really not an excuse. I just want to let you know that give me this time to tell you that I apologize sincerely for my actions. It won't happen again. And if you allow me to get on this probation, I will succeed. I'll be successful through these programs. And absolutely just make sure that I'm starting to live the righteous way and just keep on living life and strive for greatness.
What specifically are you apologizing for?
Well, for the astounding and the time that I said that I was going to be there for the court sentencing and I never was. I just had other things going on and I just wanted to apologize to you that the last time I did talk to you, that you were, that's the last time we met, and I just wanted to apologize about that.
Okay, yeah, I was gonna have you address that because I wasn't gonna go and have an allocution that didn't address the fact that last time I saw you was in April. You were supposed to, yes. You should have been sentenced by now. And that you not only failed to appear for your sentencing, you failed to appear within 48 hours to have the PSI done. I had to remand you to get you here today. I don't know how any of these things makes him a good candidate for special status and probation. He doesn't shown the court that he follows the court order. So what has changed that's going to make me feel like that if I put you on a term of probation, you're going to appear when you're supposed to appear, you're going to test when you're supposed to test, and you're not going to abscond again?
Well, I just feel like this last 56 days that I had incarcerated taught me a lot about just being responsible on, you know, on having a job, you know, being responsible on doing the things that I'm supposed to do, and basically just, you know, following directions, and so basically just going with the plan. Hopefully I can, you know, show you otherwise.
So I've reviewed the report and the recommendation. It is clear and evident by the report that there is a underlying substance abuse issue that likely needs to be addressed. Reports of early marijuana use, some alcohol use, and then obviously some use, some use of cocaine. So I think getting some treatment would be in your best interest if you intend to do what you say, which is to live a righteous life. You're gonna need to get some counseling and some treatment.
Yes, no, for sure. I definitely, I'm willing to put in this time with you and I will be successful. I will not let you down. I just can't really stress enough about it. I do apologize about that. Of the lack of responsibility that you're giving me. I just feel like I just need to make it up and redeem myself and just move forward with my life.
I'm gonna adopt the report recommendation, and I am going to sentence you to 9 months probation. While on probation, you have the following conditions. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. You understand that?
Yes, I do.
You're gonna be required to submit to random preliminary drug testing and urinalysis testing, and you have to pay the cost of that, okay?
Yes,
You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to be at any bars or nightclubs. You're not to engage in any assaultive or threatening behavior. You are required to obtain and maintain employment and provide evidence of that to your
Okay.
probation officer.
yes,
But in order that you participate in some substance use education program,
yes,
$7411 will be granted.
thank you so much.
There's a $30 per month oversight fee that you're responsible for while on probation. It's a $75 crime victim rights fee that must be assessed. $50 state minimum cost that must be assessed.
Okay,
$395 in fines and costs. I'll waive discretionary fines at this time. You're also going to be reporting virtually via Zoom, and you'll make monthly payments on the $395, okay?
okay,
Do you have any questions at this time?
no, I don't.
Excuse me?
No, I don't.
Okay. Lastly, and I don't see one attached to this file, it should be an advice of rights as to probation. And it explains that you have the right to request early discharge from probation after you've completed half the original term ordered by the court, so long as you've not had any violations within the 90 days preceding that request. You would make your request by using the court's MC 512 form. That's the notice regarding eligibility for early discharge. You would complete that form, file a copy on the probation department and a copy on the prosecution's office. The prosecutor's office has 14 days from receipt of that notice in order to file any written objections to your early discharge, okay?
Yes, okay.
If I set it for hearing to address the request that you've made for early discharge, then you have the right to hire an attorney to represent you. You do not have the right to court-appointed counsel to represent you for any such hearing, okay?
Yeah.
Do you have any questions about that?
No, I don't.
What's your home address?
Oh, 238 East Randolph, 48906, Lansing, Michigan.
And your phone number?
517-619-7256.
Any additional matters for the record today?
Nothing from the people.
Nothing from the defense, Your Honor. Thank you.
You check in with probation within 48 hours of your release, okay?
All right, thank you so much.
You're all set.
Appreciate it.
You can let the deputy know you're all set.
Okay, you have a good night and thank you so much.
Thank you.
Thank you.
On the record, in the matter of the people of the state of Michigan versus Justin Caswell. File number is 22-03524. Stop for appearance.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Caswell.
Okay, Mr. Caswell, today's date we're proceeding on sentencing here. You have a pre-sentence report, however, it was prepared back in April 12th, 2024. And so who knows how much of this is still relevant or accurate? Any updates, corrections, or deletions?
Not at this time, Judge.
He still has 2 cases pending at the 12th Circuit or 12th District Court.
He does, Your Honor, but he has pled to those cases and he's scheduled for sentencing in April for those cases. He is out on bond on them.
In April
In April,
of 2025.
yes.
Okay, this is April 2024. So I'm confused. He pled, and why is he sentencing so far out?
I'm not sure. Do you know Mr. Caswell?
I do not.
Is he being held on something?
Just this case. He did previously have other holds that were holding him in.
Let's see. We can make allocution.
Yes, Your Honor, we'd ask the court to follow the recommendation put forward in the PSI sentence. Mr. Caswell for a term of probation of 12 months with the programming for the substance abuse treatment. He is willing to complete that treatment and admits that he has a problem. I have spoken to him. He does have a place where he can stay down in Mason. And he also has a job where at the GM plant that he can go back to if he's released on probation. I think treatment would be a good option for him, and he is willing to complete that treatment. So I'd ask the court to follow the recommendation.
Why should I put him on probation when I had to remand him so I can sentence him?
Your Honor, I know that he had some other holds, and I believe that the delay between sentencing and when he pled were because he was in a bunch of different places. And I think that mix up and having holds in a bunch of different counties is part of the reason why he was not here. There was multiple times where we had to get this adjourned to figure out where exactly he was at and get him to court.
Not Mark. There was one time he was not brought over on the writ. That was May 17th. He was released since then. He was not in custody of a jail. He didn't appear. He told the magistrate he couldn't make it. That was as simple as that. He said, I couldn't make it. Why would I put someone on probation that blows off court and says, well, I just couldn't make it? And then here we are, almost October. Mr. Caswell, can you explain? Because Ms. Robinson can't explain why you just blow off court.
Yeah, I was stuck in another county homeless. That's
So
the
you were
reason
stuck
why.
in another county doing what?
Homeless. I was in another county, over in Jackson, you know. I did not
You were
show
in
up.
Jackson?
Yes, ma'am.
Okay, and then you were homeless, so you were sleeping on the street?
Correct.
Okay, and how did you get here for this court date?
Because Jackson, this county came to pick me up from jail.
So you got arrested in Jackson County?
Yeah. Yes.
Okay, and then, so because you were homeless, you're saying that your phone wasn't working because you gave us a phone number?
And I don't know, I didn't have that phone, I lost that phone. Just got a new phone.
They don't have any libraries in Jackson County?
Your Honor, I'm sure they do. I mean, I'm not gonna sit here and give you a big old story. I'm sorry I didn't show up. I'm sorry for wasting your time. Well, here I am.
He's not a good candidate for probation. He doesn't even have to take any responsibility for when he's supposed to be in court. He's got other matters pending. I'm not gonna chase him down in another county because he can't get to court or work his phone or find a library when he could have appeared for a sentencing virtually. He did not have to come to Ingham County to appear in court. If you want to take advantage of the privilege of doing probation, then you need to follow the court orders. And blowing off court since May and then telling the court, well, I just couldn't make it, that's not going to be sufficient. You're not demonstrating that you're going to now make it when I tell you to go do your drops. You're not telling me that you're going to make it if I tell you got to go do treatment. That's not what you're telling me. So you're going to do a straight jail sentence. You can be released to inpatient treatment if you're screened and eligible for such. I don't know what he's eligible for because the last time I had him screened was in April. Sentence will be 365 days Ingham County Jail. He has credit now. I don't even know the updated credit because he has it. This is from, again, April. And I know he served time back in December. one day, and then he was in custody for about 30 days between January and February on this matter. Well, let me see. Who was in custody on that matter? Yeah, because I think December 2023, he was remanded. Let's see. And then he was remanded again in January 30th. Tried to remand him a number of times on this file. I'm just trying to see if he actually had a bond. I PR'd him on the 29th of April. Okay. I'm sorry, 29th of February 2024. I PR'd him. Let's see. I'll have probation get an updated calculation of what time he actually has served on this. He'll get credit for that. And he'll serve the balance in the Ingham County Jail unless he is screened and eligible to be admitted into inpatient treatment. He can go immediately into inpatient treatment to serve the balance of his term if he doesn't complete the inpatient treatment, and that's provided he's eligible. If he doesn't complete it, he'll return back to Ingham County Jail to serve the balance. Do you have any questions about that? Do you have any questions, Mr. Caswell?
No.
Okay. Any additional matters for the record?
Nothing from the people.
No, Your Honor.
You're all set, sir. What's your name in post one?
You talking to me, ma'am? I'm sorry.
Yes, what's your name?
Matthew Shaw.
What judge are you looking for?
I have no idea. They literally just grabbed me and asked me to sit down. I did not.
Okay, can you have the deputy come in?
Yes, ma'am. Give me just 1 second, please.
No problem.
I believe he probably was
Hey, Debbie.
on the docket.
Yeah, I'm just here in a room by myself, to be honest. I just went out there and asked, and there's nobody out there.
Okay, Mr. Shaw, just sit tight.
Yes, ma'am. I apologize.
Mr. Shaw, if you can
Yes,
let
ma'am.
the guards know that you don't have court today and you're free to
Yes,
go.
ma'am. Okay, I appreciate you. Thank you very much, Ron.
Okay. You just need Mr. Markarian. You write a note on this. Nice.
Yep.
Morning.
Morning. Mr. Markarian.
He went to let the victims, relieve the victims.
What victims? I haven't called the case that had a victim. I'm not. Okay. We don't release any witnesses until
Yes,
after
I apologize.
he's been waived. Okay, let's see here. Mr. Yang is supposed to be waiving something.
Yeah.
They're not here. Yolanda can go and get them. Let's see. I did Caswell. And I saw Mr. Abbott dip in and dip out. Mr. Feigelson, you have Egleston?
I do, Your Honor.
Are we running?
I believe we're gonna run that exam this morning.
Okay, when Yolanda returns, I'll have her bring him up. And then Mr. Goodrich.
Mr. Belton's matter is going to be a plea.
Okay, are we prepared?
You're sitting 2 seats down.
Oh, sounds good. On the record in the matter of the people of the state of Michigan versus John Belton, 24-02579, appearance please.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Belton, who's standing to my right.
We have an advice of rights.
Yes, we do.
Thank you. Okay, Mr. Belton, how are you?
All right.
Okay, today was the date set for a preliminary examination. The offer from the people is for you to plead guilty to an attempted resisting and obstructing under MCL 750.81. That's a misdemeanor maximum penalty of 1 year and or $1,000. You want to accept that offer? Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Okay, this is an advice of rights with the information sheet. There's 2 pages. This is a signature page. Is that your signature? Did you read these rights? You understand all the rights here? Is that a yes?
Yeah.
You want to give up these rights today? Okay, you have the right to the presumption of innocence. So that means you have the right to proceed to trial and be presumed innocent. You want to give that right up? You have the right to see and question in court any of the witnesses that the prosecution intends to call against you. You have the right to remain silent and not have silence be used against you. You can waive your silence and testify if you'd like. You have the right to subpoena witnesses to your trial to testify on your behalf, which you have the right to have the prosecutor prove each element of the charges being brought against you beyond a reasonable doubt at your jury trial. Those are all rights you would have to give up today in order to accept the offer. You understand that, sir? Is anyone threatening you to get you to waive your rights and enter a guilty plea to the amended charge? Has there been any promises extended to you, not stated here on the record, in exchange for you entering a guilty plea today? Are you currently on probation or parole? Are you employed? You understand that by entering a guilty plea, that it could result in a conviction that you may need to put on a future job application. It also could have an impact on travel or immigration status that you may seek in the future. So you may want to go up to Canada for the weekend and they could deny you entry. You understand that? Oh. As to the amended charge of attempted resisting, obstructing, how do you plead? Is that because you believe you're guilty?
Yes.
Counsel.
Your Honor. Mr. Belton, on or about August 29th of 2024, were you a passenger in a vehicle at roughly 100 Hodge Avenue?
Yes.
And is that in the city of Lansing, County of Bingham, state of Michigan? And was that vehicle pulled over by officers from, I believe they're state troopers, Michigan State Police?
Yes.
And you recognize that they were police officers, correct?
Yes.
And after the car pulled over, did you take off running out of the vehicle?
Yes.
And did the state troopers tell you to stop?
Yes.
And did you ignore that order and continue running away from them?
Yes.
And then they eventually caught up with you?
Yes.
Okay. Your Honor, I believe we have a factual basis for attempting, resisting, obstructing an officer.
People are satisfied with the factual basis.
The court is satisfied as well. I find you pleaded made freely, voluntarily, and intelligently. This matter will be set for sentencing November 14th. November 14th at 9 a.m. When you leave here today, you're gonna go down 1 floor to the probation department. You're gonna check into the, get you all set up for a pre-sentence interview, okay? Okay. Let's see. Any additional matters for the record today, counsel?
Nothing from the people. Thank you.
Nothing from the defense, Your Honor. Thank
Get
you.
your notice to appear, okay? On the record, in the matter of the people of the state of Michigan versus Angel Robinson, 24-02587, counsel appearance.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
Good morning, Your Honor. Joseph Yang on behalf of Miss Angel Robinson, who is president to my right.
Okay. was the date that was set for a preliminary examination? And my understanding is that we're not writing an examination.
That is correct, Your Honor. Ms. Robinson and I have had a discussion about her rights to preliminary examination. We're prepared to waive the preliminary examination to continue negotiations in the circuit court.
That's correct, ma'am? So you understand, ma'am, that you do have the right to have a preliminary examination. You're being charged in one count with malicious destruction of personal property with a maximum penalty, 5 years and or $10,000 in fines. There's also an habitual offender second offense notice. You understand that?
Yes.
Do you understand that?
Yes.
Okay. And so the habitual offender enhances the maximum penalty. You recognize that? Okay. And you understand the right to require the prosecution meet their burden of establishing that they have sufficient probable cause that these crimes were committed and a sufficient probable cause that you were the ones to commit these crimes. There's nodding.
I didn't understand that. I'm
There's
like,
nodding. And let me first explain something, because I don't like it when I'm talking to them and you're feeding them responses. I don't like when your time to counsel was before they got here. Now it's my time to understand that she understands her rights versus she understands you telling her to say yes. It's exactly. If you don't understand your rights, you say you don't understand it. It's your right to waive. Your attorney can counsel you. They cannot waive it. So you have the right to have a preliminary examination. At your examination, you have the right to require that the prosecutor put forth evidence that would show that they have enough probable cause that these crimes that you're charged with were committed. And enough probable cause to charge you as the person who did the crimes. That's what I'm asking you. Do you understand that right? Okay, you understand that you would be giving up that right by waiving this? Is that what you want to do? Anybody threatening you to get you to waive your examination?
No.
Has there been any promises extended to you to get you to give up your examination? Okay, so you understand the matter will be bound over to the circuit court. Is there an offer?
At this time, the negotiations will continue in circuit court, Your Honor.
You can't later change your mind and say you don't like your offer, you want to continue with your exam and have them establish that they even have probable cause once this matter is bound over. You understand that?
Yes.
Okay.
Just go grab Mr. Stevens, Your Honor.
No problem, thank you.
There you go.
Approach.
Oh, yes, thank you. Okay, find your waiver to be freely and voluntarily given. The matter is going to be bound over for a bind over date of October 2nd. That's the date the circuit court gets the file from the district court. That's not a date that you, ma'am, need to appear in court, okay? Your next court date's going to be a pre-trial at the circuit court. Your attorney will be made aware of that. Do you have any questions today? Okay, the bond. It's 10,000 cash surety that will continue. You have a scram tether as well? Okay, that will also continue. Any additional matters for the record?
Nothing from the people, thank you.
Another from the defense, Your Honor. Thank you.
We're all set. They can bring it back up if they have a question. Mr. Egleston can be brought up. Well, is Mr. Ferguson? Oh, there he goes. Mr. Egleston can be brought up.
Yeah.
I saw Miss Donnelly, but I don't see her anymore. Is Asa Williams here? You're represented by Miss Donnelly?
Yes.
Okay, we need to wait for her to come. I just want to know if you were present.
Okay.
Mr. Abbott, you have Kevin Anderson Mallet with you?
Yes, Your Honor, he's here.
Are we running an exam?
Yes, Your Honor.
Your Honor, I don't have the necessary witnesses here on that one, so we'll be amending the complaint to a misdemeanor.
On the record in the matter of the people of the state of Michigan versus Anderson Mallet 20-01427, counsel appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
Good morning, Your Honor. John Abbott representing Kevin Anderson Mallet. He's standing to my right.
Okay, this is the date set for a preliminary examination. Let's see, there was a larceny for persons of computers, domestic violence, and then intentional dissemination of sexually explicit visual material. And you say you do not have the necessary witness here?
No, Your Honor, I don't. Necessary witness Adriana Ireland has been difficult to make contact with. However, I am amending this complaint to just be counts 2, 3, and 4 because I believe I could proceed victimless on this case if necessary.
Counsel.
Your Honor, I'd object to the amending of the complaint. I support to dismiss the case. I'm not sure how they intend to proceed if they don't have a witness that can identify my client or the person who may have been involved in the crime.
I don't know how they intend to proceed either, but I mean, I can't accept your objection to him dismissing one count. Or that's all he needs to do. It doesn't really need to amend the complaint, just needs to dismiss the felony.
Okay.
So motion to dismiss, I guess, is granted.
Thank you.
Okay, so we'll get you a pre-trial date. Actually, I'll put up a final pre-trial. This is a 2020 case.
Yes, sir.
So I can almost guarantee whatever trial date you get, it's going to be the priority. You're going to be the priority case because of the age of the case, okay?
As in age.
Oh, the case is old, 2020.
Oh.
So if I get you a trial date today, there probably are other trials scheduled for that date as well. But your case would take priority because it's a 2020 case and those probably have newer case numbers, okay?
Do October 22nd.
Final pre-trial.
Yeah.
October 22nd for your final pre-trial.
How far out do you guys normally do your juries?
Just next available date.
Oh, okay. I didn't know if you do. Sorry. Jury will be the 29th.
Jury trial, October 29th. Both are going to be at 8 a.m. in person at the court, okay?
Is it any way it could be a little like 9? Because I have custody of my daughter. She get on the bus at 8:20.
You drop your daughter off at 8:20?
Well, she leave out the house and go to the bus stop at 8:20.
Okay, so I was actually just gonna ask the prosecution because they intend to run this victimless. So I don't really know what's going to happen at this final pre-trial because the victim doesn't appear. I'm sure there'll probably be a motion, but your intention is to try to run this without a victim.
Yes, Your Honor.
So I'll move it to 9 o'clock to accommodate him having to drop his child off. However, we can't move jury trials to 9 o'clock. So you're gonna have to find arrangements for the 29th, okay?
Okay.
So you can appear at 9 a.m. On October 22nd. You still have to appear at 8 a.m. if we're going to trial on the 29th, okay? We'll get you a notice to appear. Any additional matters for the record?
Nothing from the people.
Nothing from the defense. Thank you.
No problem. Sorry. Who do you have there?
Mr. Egleston.
On the record in the matter, the people of the state of Michigan versus Asa Williams, 23-02992 FY.
Morning, Your Honor. Case Mark Aaron, appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Asa Williams, who is present to my right.
Okay, Mr. Williams, today was the date scheduled for a preliminary examination And the prosecution is going to amend the complaint.
Yes, Your Honor, we'll be amending it to one count of attempt resisting an obstruction. Makes sense to me.
Counsel, do you want a pre-trial date?
A pretrial date is fine. Thank you, Your Honor.
October 15th.
At 1:30.
October 15th at 1:30. Have any questions today, sir?
No.
Okay, we'll get you a notice to appear. Any additional matters for the record?
Nothing from the people.
Your Honor, I guess we should address bond.
You can proceed.
Your Honor, this is the case where there was an issue where, well, adjust it. That when he was remanded by your office for a failure to appear, he was having issues. He has health issues. He was in the hospital. In fact, he's got an appointment here soon at like 10:15, and he should be able to, hopefully he can make. But Your Honor, there was an error with the jail, and he was released sometime after his sentence was completed from Eaton County. So he's been out of custody since the 6th on a remand. He did previously have a surety. You had a bondsman post $1,500. I don't know if that's actually been rescinded yet. But you know, because he's appeared here today, and this is now amended to a misdemeanor, we'd be asking if the court could give him a personal recognizance bond or put back the surety.
Okay, I see in 2023, you originally had a PR bond. And then, let's see. It changed in November 2023 to 5,010%. Then December 7th, there was a remand. That's all 2023. And then we saw him in August.
Your Honor, did you pick up for you? June 22nd. Yeah, he did get picked up in June by Eaton County and served a sentence there.
Right, but I don't know what's going on in the Eaton County file. I can only talk about my file. We didn't see him again until August 30th. He was arraigned, and the preliminary examination was set for today. And oh, this is the individual that was released in error. That's what the issue is.
Yes.
I'm like, why are we addressing bond? Because he wasn't supposed to be released. And we typically would have sent someone to go pick you up, but we knew you'd come today. So we'll reinstate your bond, okay? I think it was. I don't know what it was. 5,000 personal recognizance, because I don't even see an amount on the last. I think this is old, the one that he posted the surety on. I think he might have already.
Last case note I have is from December, Your Honor.
December 7th, failed to appear remand. Let's see, appearance date. Bond 1250. That's the last, that's where I see Leo's bondsman posted for him, but that one he already forfeited. You said he was in the hospital then?
Yeah, he had a failure to appear where he had.
December?
Yeah.
Okay, I reinstated this bond. Okay, don't forget to appear at your next court date. Did you get your notice to appear?
Yes, ma'am.
Okay, do you have any questions?
No, ma'am.
What's your address?
3436 North Waiver Road, Mansion, 48906.
What's your phone number?
22-517-22 6872.
6876?
Yes.
Any additional matters, counsel?
Okay.
Nothing for defense.
You're all set, sir.
Thank you.
Running Naro?
Oh, Your Honor, that's the one that I requested the adjournment on. The witness is sick, has a cold, and it's contagious.
Requesting adjournment from whom?
The necessary witnesses on that one, Your
Uh,
Honor. I sent an email to the court, I'm sorry.
I see the AG is here and Jason Hulbert. Do I have that file? I do. On the record in the matter of the people of the state of Michigan versus Jason Hulbert 22-03075. Who's representing Hulbert?
That's me,
Ms. Schroeder.
Oh, okay.
Kristen
Counselor
Curtup,
Parents.
the people.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Hulbert, who joined us by Zoom. Mr. Hulbert was here in person yesterday as well. And we adjourned this from yesterday. Thank you.
Okay, yeah, I was at a state bar board of commissioner meeting yesterday, was unable to appear in person. I was listening in virtually, however, so I did understand that there was a request to waive this and have it bound over to the circuit court. Is that correct?
That is correct, Your Honor.
Mr. Hulbert, that's what you want to do?
That's correct.
Okay, and are the people waiving their exam?
Yes, Your Honor.
Counsel, you want to say something?
Yes, Sean, I apologize for interrupting. I wanted to just make a brief record. Mr. Hulbert is doing this, against my advice. I told him that I did not have the discovery yet on this matter, and I would prefer to have that before we move forward. I had asked that we leave this on. However, he has indicated to me he got information on his own from friend of the court as this is a child support matter. And he was comfortable moving forward with waiver so we could get this matter to the circuit court and get to proceedings. There's a plea offer potentially on the table that he wants to get to quickly. So while I did tell him I would prefer not to do it that way, he indicated he did, and it is his right as the preliminary exam. Thank you.
Okay, so Mr. Hulbert, that's accurate as to what your counsel is indicating?
That's correct, Your Honor.
Okay, and you understand your right to have a preliminary examination in the district court, and that the purpose of the preliminary examination is to require the prosecution, which is the Office of the Attorney General, establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that?
I do, Your Honor.
Unconditionally waive your exam?
Yes, Your Honor.
Anybody threatening you to do that?
No,
Any promises being made in exchange for a waiver of your examination?
no, Your Honor.
Typically, I wouldn't allow you to waive it if your attorney hasn't had discovery, but this is again a failure to pay child support. As indicated by counsel, you could get that information from the friend of court. And if that's what you want to rely on, I'm sure you know better than she does as to whether or not you actually failed to pay. So if you want to bind this over to the circuit court, we can do that. The bind over date's going to be October 2nd. That's the date that the circuit court's going to get the file from the district court. You do not have to appear in court on that date unless Ms. Schroeder, for some reason, files a motion to have you rearranged at the circuit court. Then you'll appear on that date for your rearrangement, okay?
Yes, Your Honor.
Otherwise, your next court date will be a pretrial in the circuit court. Confirm your address for me, sir.
My current address is 820 North Capitol, right here in Lansing.
And your phone number?
863-308-8637.
A bond in this matter will continue. Any additional matters for the record?
No, Your Honor. Thank you.
Your Honor, what was that bind over date again?
It's going to be the 2nd of October.
All right, thank you, Your Honor, nothing further.
Thank you, Ms. Berger. Thank you, Mr. Hulbert.
Thank you,
Thank
Your
you.
Honor.
Thank you, Your Honor.
It's not your matter.
Yeah.
Okay, let's see here. On the record in the matter of the people of the state of Michigan versus Christopher Navarro, 24-02502. Council appearance.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
Good morning, Your Honor. Stephen Mills on behalf of Mr. Navarro. Mr. Navarro is present, standing to my right at this time.
Okay, today was the date set for a preliminary examination, and my understanding is that we do not have necessary witnesses here.
So, Your Honor, we would be requesting a one-time good cause adjournment for this one. I spoke with the necessary witness on this one, Miss Olivia Thrush. I've actually spoken to her a few times. We've had great contact. There's also another pending case in 54B, the same victim and the same defendant for domestic violence, Your Honor. She advised me yesterday that both her child and her have gotten very sick. I asked if it was contagious and left it at that because of any sort of HIPAA potential violations or anything like that. She said that she believes it is and that she thinks it might just be a cold. But I also know that there's a lot of times you think it's a cold and it could be COVID or something else, Your Honor.
Okay, so you're seeking a good cause adjournment.
Yes, sir.
Mr. Mills.
As the court knows, I'm a very delicate individual. I don't feel like getting sick. We have no, we anticipate the court would grant a good cause adjournment, so we're not taking a position.
Thank you. The court finds good cause to adjourn this matter due to the illness of the victim and her child. And so we will reset this matter. So you have the right to have your exam within 21 days of the date that you're arraigned, but due to the witness not being able to be here, not because they're not willing to participate, but because they're ill, the court finds good cause. Okay, so we'll get you a new date.
November 7th at 8:30.
November 7th at 8:30 is your new date. Okay, sir? Okay. Do you have any questions for the court?
No, Your Honor.
Are your bond that was set at 10,000, 10%, and the no contact order that will continue? Any additional matters for the record?
Your Honor, if I may.
Yes.
There was just I just wanted to put on the record, we will consent to HYTA status on this so long as the defendant ends up waiving. I just wanted to put that on.
Offer?
Yes, sir.
That's noted. Any additional matters for the record?
We're making additional discovery requests, Your Honor, from prosecutor's office because there's a PPO that is named in this one. We expect that people do have information regarding this, but that'll be something that prosecutor and I cash out. And thank you, Your Honor.
Thank you. You're all set. All right, and the record in the matter of the people of the state of Michigan versus Sean Egleston, 24-0335 and 24-02376. Appearances, please.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Sean Egleston, Your Honor, standing to my right today.
Okay, today was the date set for preliminary examinations on both files. I got a one file to domestic violence, third, and assault with intent to do great bodily harm less than murder on the other file. And we're ready to proceed.
Yes, Your Honor, on the assault with intent to do great bodily harm case, as for the domestic violence case, file number 24-02376-FY, Your Honor, I have attempted several times to make contact with the necessary witness on that one. The officers have also, as I was reading a report yesterday, attempted to make contact with the witness several times on that one. We have a detective assigned. We haven't seen her or heard from her, so that people are unable to proceed on that file.
Counsel.
The defense stands ready to proceed the outer witness without prejudice. We'd ask for dismissal today.
That file will be dismissed without prejudice. We'll have the right to reissue it against you, okay?
Yes, Your Honor.
And we're ready to proceed on the other file.
Yes, Your
correct?
Honor. Or one preliminary matter, Your Honor, we do have a stipulated exhibit, I believe. Like me to approach now or?
Yes, please. It's the stipulated exhibit 1.
Yes, Your Honor. People can do the one.
Yes, for purposes of preliminary exam, Your Honor.
Okay, thank you.
I think there's only one witness, so I don't believe we need this request from the motion.
Yes, Your Honor, just one witness.
Thank you. You can call your witness.
People call Jerry Egleston to the stand. Your Honor, would it be okay if we? Are you ready to make that step?
Do what?
Step up here to the chair, can you do that?
Sure.
Fine. Be able to turn around at all? Towards the mic?
Turn it all.
No, that one. I need you to raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, so there's a microphone that's in front of you. The purpose of that microphone is not to amplify your voice in the courtroom at all. It is so that the court recorder, who is the lady behind you, can hear everything that's being stated in the court. So she needs to hear your response so that a record can be made. So your responses still need to be loud and clear because I have to hear your answers, okay?
Okay.
They must be verbal. It can't be head nods or head shakes. If there's an objection from either of the attorneys, you'll stop speaking immediately because I have to make a determination as to whether or not you can give that response to their question or not, okay?
Okay.
State your first and your last name, then spell both.
Jerry. Jerry Eggleston. Eggleston.
Thank you, counsel. You can proceed.
Judge, may we approach for a second?
Okay. Okay, counsel, you can proceed.
Thank you, Your Honor. Good morning, Mr. Eggleston.
Morning.
How are you doing?
Oh, so
I saw you were getting a little emotional there. Do you know?
my hearing is bad.
Fair enough. I know you have some bad hearing too, so I'll speak up as loud as I can. Can you hear me at this volume?
Yes.
Okay. Do you know someone by the name of Sean Egleston?
Yes.
How do you know that person?
My son.
Is that person in the courtroom with us here today, sir?
Yes.
Would you please point him out and identify him by an article of clothing he's wearing?
Yeah.
Your Honor, please let the record reflect the witnesses identify the defendant.
No objection.
Please noted.
Are you familiar with the location of 127 East Mason Street in Lansing?
Yes,
What's at that location, sir?
it's my house.
Is that located in Ingham County
Yes,
here in Michigan?
yes,
I'm going to take you back to the date of December 31st, 2023, New Year's Eve. Do you remember that date?
fairly.
How do you remember that date? Did something happen?
Yes, I got in an argument with my son. And I got up to my chair, go to the bathroom, and he jumped me.
Okay, let's break that down a little bit, okay?
I don't understand.
Let's just break it down a little. I'll ask you a couple more questions, all right? So you said you got in an argument. Would it be fair to say that that started verbal and then turned into a physical one?
Yes,
What was the argument about without telling us what anyone said specifically?
I can't remember. It was so trivial.
Was it some big important issue, something insignificant, or
Insignificant.
just an argument between father and son? Yes?
Yes,
At some point you said you stood up. Why did you stand up?
I had to go to the bathroom.
And then what happened when you stood up to go to the bathroom, sir?
He jumped out of his chair and he jumped me.
What do you mean by he jumped you? What did he do?
He come around me, got me in a chokehold, but tried to put me in a sleeper. And I started to pass out and he dropped me to the floor. That's where I broke 2 ribs.
Did he say anything to you while he was doing this?
I can't remember.
Now, you said that he put you in a chokehold and jumped you. What do you mean by a chokehold?
Like a wrestler's chokehold. Sleeper, it's called a sleeper.
Could you demonstrate maybe?
Come around my neck like this and you're pinching off this artery and this one.
Your Honor, please let the record reflect the witness has just demonstrated putting his right arm up to his neck in a sleeper hold type position.
Noted.
Did you, this might be a silly question, okay, but I gotta ask it. Did you ask for him to put you in a sleeper hold?
No,
Did you in any way suggest that you were going to attack him and that's why he did it?
no,
Mentioned that he put you into a sleeper hold and you said choked you out. What do you mean by choked you out?
I passed out.
You passed out, so you lost consciousness.
Yes,
Do you know how long he was choking you out for approximately?
a few seconds, I think. I'm not really sure. Time kind of went fast.
Fair enough. So you think he was choking you out for a few seconds, but you lost consciousness. Is that fair to say?
Yes,
Can you think of any other reason aside from him choking you out why you might have lost consciousness?
no,
So that was the reason.
yes,
Now, at a certain point, you said that you broke 2 ribs as a part of this. How do you know that?
because when I got up, I went and laid down so that we wouldn't argue no more. And all of a sudden I woke up screaming and I had a real bad pain right here. I called the ambulance and I went to the emergency room. They x-rayed me and I had 2 broken ribs.
Now, when you said you had pain right here, could you describe where you were pointing?
Right here on the top of my ribs, they go to the rib cage.
On the left side of your body?
Yes,
Did you receive medical treatment for that?
yes,
How long were you in the hospital?
few hours.
Did they perform a surgery or anything
No.
like that? Your Honor, permission to approach and retrieve people's exhibit number 1. Approaching the witness with the same. I'm going to show you a photograph here, okay, sir? You just tell me if you recognize that. You recognize that person in that photo?
Yes, me.
That's you. When was that taken? Do you know?
Probably the night I went to the hospital.
Okay. And what are we seeing in that photograph thing?
You're seeing me laying on a stretcher with a bracer on my neck.
How did you end up in that stretcher with the bracer on your neck? Was that a
I
result
can't
of,
remember.
was that a result of this incident?
Yes,
Mr. Eggleston, is there an age difference between you and your son?
Yes, quite a bit.
How much?
Objection, is there relevance to the age difference between father and son?
Do you want to respond?
Yes, Your Honor, I think this goes towards the intent that I have to prove here, the intent to cause great bodily harm. I would suggest a younger man attacking a father who's much older under any circumstance is potentially assault with intent to do great bodily harm. And he strangled him in this instance as well as Weaver.
Maybe not the age difference because, and this is just hypothesizing, let's say he's 25 or he's 50 and his son's 25. He's not considered elderly. Maybe his age might be more relevant.
Fair enough, Your Honor. Yes, I'll rephrase. Mr. Eggleston, how old are you?
72.
I saw you walking in with a chair, with a cane. What, do you have any health problems?
Yes. I still got 3 bullets in me from when I got attacked years before.
Was your son aware of these health problems when this incident occurred?
Yes.
Did I leave anything out that you think the court should know?
Objection,
Well-
is there relevance to anything else for this question?
Do you want to respond?
Just making sure I didn't miss anything, Your Honor. Rephrase.
This is Dave.
What, if anything else, happened after you went to the hospital that might be relevant to this case?
He kept getting on the phone trying to get a hold of this guy. And I asked him why, and he said because he wanted that guy to come over and help him kill me.
Wait, he said he was on the phone trying to get a hold of who? Your son?
No, he was trying to get a hold of this other guy that he knew.
Okay. Okay, while you're in the hospital, you saying your son was on the phone trying to get a hold of
No,
someone?
it's happened at the house.
Oh, at the house. He was trying to get a hold of someone he knew?
Yes,
For what purpose?
to have him come and help kill me.
Okay.
Thank you, Your Honor. I have no further questions.
Process.
Thank you. Good morning, Mr. Eagleson.
I can't hear you.
Said, good morning, sir. Can you hear me now?
Yes,
So on December 31st of last year, you were watching TV in the living room. Is that correct?
yes,
And your son was present as well?
yes.
Was anybody else present during that time?
There was one guy there, they call him D. I haven't been able to get a hold of him.
So you, Sean, and Dee were watching TV. Is that correct?
Yes,
Do you remember what you were watching?
pardon?
Do you remember what you were watching?
No,
Okay. And you said all of a sudden there was an argument. Is that correct?
yes,
You said something trivial. Is that correct?
yes, it was
Not
something
important.
you would just overlook.
You guys talking about your friend Amber that night?
Pardon?
Objection, Your Honor. Relevance, more prejudicial than probative.
Do you want to?
Your Honor, may we approach?
Yeah. Okay, back on the record. Counsel, you can proceed.
Thank you, Your Honor. Mr. Egleston, so you said the matter you were arguing about on December 31st was a non-trivial matter, is that correct?
It was a trivial matter. I looked at it as no importance.
Okay, got it. Were you discussing a missing person that night? That's a
I
yes or
can't
no?
hear you.
Were you discussing a missing person that night?
I can't remember.
Okay,
If you don't remember, how do you know that it was trivial?
I'm sorry, what?
How do you know if it was a trivial matter if you can't remember what you were discussing?
Because it didn't seem important at the time.
Okay.
and then you said after this argument, you got up to go to the restroom, is that correct?
Yes,
Did you get in your son's face that night?
no,
And then and how far did you get from your chair as you're going to the restroom before something happened?
maybe from right there to right there.
Okay. And what did Dee do while all of this was going on?
What is what?
The other person in the room do? What did Dee do?
You just stood there and watched.
How long did this incident last?
I can't hear you.
How long did it last?
Did what last?
The incident between you and Sean, how long did it last?
Just a few minutes.
Okay. Then you said you went to sleep after that, is that correct?
No, I went and laid down.
Okay. And then at some point you said you went to the hospital because you had pains, is that correct?
Yes,
Your Honor, I have no further questions from Mr. Egleston, Your Honor, thank you.
Redirect.
Yes, Your Honor. Mr. Eggleston, how you were talking about, or you were asked about how long this all lasted on cross-examination. At any point, did you have difficulty breathing during this incident?
but just when he had his arm around my throat.
Thank you, Your Honor. I have no further questions.
Okay, this is your only witness.
Yes, Your Honor.
Okay. You can help him off the stand, but he can sit in the back of the courtroom. Because we gotta address an issue with them, so he can sit in the back of the courtroom for now.
Send back.
What is it? Right out here.
Yeah, you just make this up.
Got it?
I think so.
You want me to hold this?
Yes, please.
Got it.
Thank you.
Jack is gonna want you to sit right back here.
All right.
Okay, any other witnesses?
No, Your Honor, people were asked.
Any witnesses from the defense?
None on behalf of Mr. Sean Egleston this morning, Your Honor.
Okay, you can make argument.
Yes, Your Honor, thank you. As Your Honor is well aware, we're here for a preliminary exam on the matter of Sean Egleston. All I need to prove is that a felony was committed, specifically assault with intent to do great bodily harm by strangulation or suffocation, and that this defendant is the one who committed it. Regarding the preliminary or administrative elements, whatever you want to call them, we have location, identity, venue, and date all confirmed on the record by Jerry Egleston. He identified the defendant as his son, Sean. He's known him his whole life, so I think the identification is good. He identified the location of 127 East Mason Street as his home in England County, Michigan, and he recalled the date of December 31st, 2023. Regarding the elements I have to prove, Your Honor, he is charged with assault with intent to do great bodily harm by strangulation or suffocation. I'm looking at Michigan Criminal Jury Instruction 17.35 for those elements. I have to prove three things today. First, that the defendant committed a battery on Jerry Egleston. Second, that the touching must have been intended and against Jerry Eggleston's will. And third, that the battery was done by strangulation or suffocation, namely that he was impeding normal blood circulation or breathing by applying pressure on the throat or neck. Your Honor, regarding those three elements, I think the testimony was very clear, although a bit brief, about what happened here. There was an argument over a matter that seems to be a little up in the air, but that Jerry Egleston described as a trivial one, that he didn't think was a big deal. He stated that he got up, went to the bathroom, and that's when his son jumped him and started applying a sleeper hold, choking him out until he was completely unconscious. He has described not only difficulty breathing when this happened, but Your Honor, being choked out to unconscious, the point of unconsciousness is impeding normal blood circulation and would qualify as battery done by strangulation or suffocation. I would also request, Your Honor, that we add an and/or to the charging of this based on the testimony about the broken ribs and the fact that Mr. Egleston is 76 years old, I believe he said. For that, I'm looking at criminal jury instruction 17.7, assault with intent to do great bodily harm less than murder. Defendant had to try to physically injure another person. The defendant had to have the ability, or at least believed he did at the time of the assault, and the defendant intended to cause great bodily harm. And although injury is not necessary under that instruction, it may be considered. We have a 76-year-old man who was attacked by his son and ended up with 2 broken ribs as a result of this. He went to the hospital the very same night. You have the photograph there in front of you for proof, Your Honor. So I wouldn't be requesting to add an additional count, but I would be requesting to amend the language of our current count 1 to be, did make an assault upon Jerry Egleston by strangulation or suffocation and or with intent to do great bodily harm less than murder. So that way we have both.
Thank you, Your Honor. I'd ask for these charges not to be found over today. Let's take a look at Mr. Egleston's testimony here today. I think what's paramount is when we talked about what started with the charge, and we said it was something unimportant, non-trivial, trivial matter. Yeah, when I asked him about something else, about whether it involved a missing person, it's like I don't remember something non-trivial, uncertain, something. I don't really know there was a strangulation. He says he went to the hospital, but he's 72 and frail health. There's no real evidence other than his statements put on the record that this happened. And I'm not sure you can take his credibility based on some of his lack of memory from the events that has to just not be found over. I know it's a low standard of proof, but that's what I'd ask for today. Thank you.
Date set for preliminary examination. The burden is squarely upon the prosecution to establish sufficient probable cause that a crime was committed and then probable cause sufficient to charge you, Mr. Sean Egleston, with the crime. It is not a trial. They don't need to prove each element beyond a reasonable doubt. It's just more than mere suspicion that the crime alleged occurred. In this matter, the crime being alleged is assault with intent to do great bodily harm less than murder or by strangulation. I will be the sole determiner of credibility of the witnesses, and I will also make an assessment of the people's likelihood of success at trial. We had testimony again from one witness, that being Jerry Egleston, who is the alleged victim in this matter, and the argument of the defense is that because Mr. Egleston could not answer as to whether or not the matter was about a missing person after he had testified that it was trivial, that the credibility of his testimony should be discounted. And from the beginning of Mr. Egleston, Mr. Jerry Eggleston's testimony, he was asked by the prosecution if he remembered this incident. My recollection of his response was barely. He prefaced it from the beginning that he had some limited memory. He also now testified that he's a 72-year-old man. It obviously has some health concerns. He could barely make it from back there to the jury. I'm sorry, to the witness stand, and accommodations were going to have to be made for him to have to even give his oath of office. He also testified about being a victim of a prior incident, which caused him some health concerns. So we have an elderly individual with some health concerns that may have or may not have contributed to his lack of memory about some of the details. But not being able to remember some details does not discredit the entirety of a testimony. He testified with particular clarity that on or about December 31st, which was New Year's Eve 2023, He was at his home at 127 East Mason Street. That's in the city of Lansing, Lincoln County, state of Michigan. He recalled getting into an argument with his son. He recalled another individual being there. He said that he stood up to go to the bathroom and that his son jumped him. He described being placed in a chokehold and also described and demonstrated what he said was his son's attempt to put him in a sleeper. He said as a result of the incident that he suffered broken ribs, that he had fallen asleep or laid down, I should say. He said at the time and woke up or got up screaming because of some pain. He called an ambulance and he was transferred to the hospital later to determine that he had broken ribs. He also gave some testimony about his son trying to get someone else on the phone to come over and help him kill him. And so the court can't just state that just because he couldn't remember some aspects of the day or the altercation or the incident, that these things that he does remember are not credible, because there are times, countless times, and this is supported by evidence, that some people who suffered traumatic incident can only remember certain portions of that traumatic incident. The people have charged this as assaults with intent to do great bodily harm, less than murder, or by strangulation. They're requesting to amend the complaint to add an and or, including or inclusive of jury instruction 17.7, which is assault with intent to do great bodily harm. The court will grant the request. The court is satisfied based on the testimony that there is sufficient probable cause. And so the matter as amended will be bound over to the circuit court. Bind over date is October 2nd. You don't need to appear in court on that date. That's the date the circuit court gets filed from the district court. Do you have any questions at this time?
No, Your Honor.
Bond was set at 10,000 cash surety with a no contact order, not to be within 2,000 feet of the alleged victim, not to have contact directly or indirectly. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing on behalf of Mr. Egleston, Sean, Your Honor.
Bond will continue. You're all set, sir. Mr. Jerry Egleston. You got some old dog cases here. Did you know about that? Yes, sir. Can you hear me?
No.
You have some very old dog cases, dog at large. I think all of them are dog at large. That were originally before Judge Alderson. So I have to arraign you while you're here for them, okay?
I can't understand you, Your Honor.
Maybe he can come a little closer. I don't know if he can. I'll try to yell so that you don't have to move. You have 3 dog at large cases. They're really old.
I got one that I know of.
Well, I have 3 here,
I
okay?
only know of the one.
You were never arraigned on them.
No,
Okay,
they arrested me on one of them, but then they turned me loose
okay,
at my front porch.
okay. Well, okay, so let me arraign you so I can get you a next court date, okay?
All right.
Okay, so one, this people of the state of Michigan 20-02360, and this is for dog at large, allegedly having occurred back on August 5th, 2020, okay?
All right.
At the area of East Mason Street, city of Lansing. I think the dog is identified by the name of Sammy on that one. And then I have another dog at large, people of the state of Michigan, 21-00242. Same dog, Sammy, at the address or area of 124 East Mason. And then the last one is and file number 20-02049 is a dog at large. Same dog, Sammy, at the area of 127 East Mason Street, okay?
Yes, ma'am.
So we'll get these set for a pre-trial. They are pretty old and most of them happened in the middle of COVID. So you probably, I said, these are old files and most of these happened in the middle of COVID. So maybe you missed these dates. We'll get you some court dates. Do you have the ability to appear via Zoom?
I'm sorry, I can't understand you.
Oh, can you repeat that for me?
Jerry, can you appear via Zoom on your phone? Do you have the ability to do that? I don't know how to do it.
Okay. Would you like an attorney?
No, I think I can explain what happened. The dog pushed past my girlfriend and got outside.
Okay, let me get you an attorney. Can someone do an intake with him before he leaves?
I can do it, Your Honor.
Thank you.
October 7th with Judge Flores at 9:30.
Okay, very good. I'm gonna enter not guilty pleas on these files and note that he's requesting court-appointed counsel because I think he needs it.
I have a question.
Yes.
Why would they arrest me on that?
I don't know.
That turned me loose?
I don't know, sir, because I wasn't there, but I'm going to advise you of your right to remain silent so that nothing can be used against you, okay?
Right.
And so I'm gonna have you meet with an attorney. You can explain to that attorney in private, whatever you feel like you want to explain. I think you need an attorney on these, okay? And maybe it should be able to get resolved, okay?
All right, thank you.
We'll get him the notice to appear October 7th at what time?
At 9:30.
At 9:30, Judge Flores.
Mr. Egleston, you want to sign for this, please?
I do, man. Thank you. Then my got Dante.
Is that?
Yes.
Will you give it to- I know them.
Yeah.
We'll go down together.
Fine. Hey, Andrew, I'll have you sign this weekend back.
Here, I'll sign it right now before I go.
That's what I wanted.
And that's done. And then Mr. Austin has another matter. I met his own matter.
Guys, Your Honor, we're gonna be amending, and I didn't know if you wanted to do that real quick.
For who?
And then Ms. Peterson's gonna be a dismissal.
But Mr. Austin, your client's in custody though, correct?
Yes, he is. My understanding is the people were going to dismiss the felony and leave the misdemeanor on.
You want to waive his appearance for that?
I can do that, Your Honor, yes.
Okay.
I already advised Mr. Shannon that's what was going to happen.
Okay. Sounds good. On the record in the matter of the people of the state of Michigan versus Cornelius Shannon, 24-02619, appearance, please.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Good morning, Your Honor. Jared Austin appearing on behalf of Mr. Shannon. He's not present in the courtroom, but he is down in the locker.
Okay, today was the date that was originally scheduled for preliminary examination. The people are amending this complaint.
Yes, Your Honor, we'll be dismissing count 1, assault with intent to do great bodily harm, and keeping count 2, domestic violence, so we can leave it in the misdemeanor docket.
Okay, sounds good. And so. We'll get you a date for the misdemeanor pretrial.
October 15th at 1:30.
October 15th at 1:30. I'm assuming you're gonna want bond addressed.
I wasn't planning on it, Your Honor, because he actually has a parole hold till
Okay,
that
so-
time, so really no.
We're all set on that then. Any additional matters for the record?
Yes, so just to clarify, Your Honor, he has a pretrial conference date, that he has a trial date at this time.
I didn't set it for final pretrial. Did you, is that what you want?
I think that would probably be best.
Okay, let's do final pretrial.
The only other thing I was going to ask with that, Your Honor, I know his case is newer, but if he could somehow be elevated on the priority list because he's on a parole hold, he's not earning any credit, he's on death time.
Final pretrial can be October 22nd. October 22nd at 8 a.m. Jury can be November 4. November,
No, 5, sorry.
November 5th at 8 a.m. for jury trial. I'll note that there's a request to prioritize. Any additional matters for the record?
Thank you, Your Honor.
Oh, Your Honor, thank you.
We're all set on that one. Thank you. Thank you for helping on that one too. Let's see. Mr. Oh, I saw Mr.
Peters.
Silverthorne, but he's not in here anymore.
Yes, Your Honor. Ms. Peterson's here. I think that was
Ms. Peterson is a on the record in the matter of the people of the state of Michigan versus Mariah Peterson, 24-02593. Appearance, please.
Your Honor, case marked hearing appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder appearing on behalf of Ms. Peterson. Ms. Peterson is present and is staying to my left.
Okay, Ms. Peterson, today was the date that was scheduled for preliminary examination on a weapons charge. How are we proceeding?
Your Honor, at this time, the people are unable to proceed. I have communicated with the necessary witness on this one. He has advised me that he wants nothing to do with this case. I asked about even amending to a misdemeanor and going that way. He advised no matter what, under subpoena or otherwise, he's not going to show up. He wants nothing to do with this case.
Counsel.
With that being said, Your Honor, the defense will be motioning for dismissal.
Motion to dismiss without prejudice is granted. So you'll get a copy of the dismissal, but the people do have the right to reissue if for some reason the witness does want to proceed, okay? No problem. Hang tight so we can get you a copy of the dismissal, okay? You can have a seat back there, though.
Thank you, Your Honor.
You're welcome. Mr. Silverthorne.
Morning, Your Honor.
Good morning. Ackley, are we running Ackley?
No, Your Honor.
Your Honor, that's going to be a request to reset to Judge Flores' court to align with the other case Judge Flores already has with the same.
Can we waive his appearance for that motion?
I'm sorry.
Can we waive his appearance for that motion, or do we want me to bring?
No, that's fine.
Okay, on the record in the matter of the people of the state of Michigan versus Dayton Nley, 24-02624, council appearance.
Morning, Your Honor. Case marked hearing appearing on behalf of the people.
Good morning, Your Honor. Dwayne Silverthorne on behalf of Dayton Ackley. I'm from the Office of Public Defender.
Okay, I do see a note here. It was already on bond before Flores. So this matter was scheduled for exam today, and we want to have this matter transferred to Flores so they could both run together, I guess, before the same judge.
Yeah, that would be correct, Your Honor. In fact, we have a week from today at 2 p.m. Both this case and case 02545, which is an earlier case, will be before Judge Flores. Normally, they would have both been scheduled with him, but Your Honor was not here, and to make the timeline work, they had the schedule between. I would note that we did a PCC last week with Judge Ward in informing her that it was our wish to consolidate the cases, and I suggested that we waive the timeline in order to effectuate that. And Judge Ward felt that since it wasn't a case, she couldn't do that. So I don't know if we need to waive the timeline to get that done now.
Yeah, the timeline would need to be waived because he was scheduled today for that exam, but I'm going to find the cause due to case consolidation to waive it.
Okay. And there's an additional note that is of the last minute. I met with, as I typically do, met with Mr. Ackley and lockup before, and he had informed me that relatives of his grandmother had retained an attorney from the Detroit area. Moments ago, I stepped out because I had gotten a call from his aunt who confirmed that someone will be subbing in, just didn't know the name, so I gave her my email, sent it to me, and I'll pass it along to the prosecutor's office. Both both to this gentleman and also to Ms. Wilson over in Judge Porter's court, because I would anticipate that someone just coming into the case might want to request another adjournment.
Sounds good. We'll set it for the date that you have. It's next week, you said?
Yes, yeah, it would be September 27th at 2 p.m.
Okay. Before Flores. Any additional matters for the record today?
Nothing from the people. Thank you.
Nothing to the defendant. Thank you, Your Honor.
You're all set.
All right, thank you. Have a good weekend, Your Honor.
Same to you. And
I think Robinson's going to be an adjournment request. Mna Jr is going to be an amendment to the complaint.
oh, I accidentally crossed off adjournment. That's what, I mean, Robinson. I don't see Mr. Ferguson.
Must have just
On the record, in the matter of the people of the state of Michigan versus Eduardo Magana. 4-01830, council appearance.
Good morning, Your Honor. Jason Markarian appearing on behalf of the people.
Good morning, Your Honor. John Abbott with the Public Defender's Office representing Mr. Magana. He's standing to my right.
And that's Eduardo Magana Jr., correct?
Yes, ma'am.
Okay, today was the date scheduled for a preliminary examination. How we proceed?
Your Honor, at this time, the necessary witness Veronica Mna Jr has failed to appear. We are unable to proceed on the preliminary exam. However, I will be moving to amend the complaint to keep it as a misdemeanor, to amend count 1 to be attempt interfering with electronic communication, keeping count 2 the same. If I may make a record, Your Honor.
Right.
There is a extensive history between these two of domestic violence. A lot of cases have gotten nollied. A lot of cases have gotten dismissed. And a lot of the time, my suspicion is it's the defendant getting the victim to not show up to court. Your Honor is well aware of how we handle these types of cases and that we're able to proceed victimless on it. I anticipate there will be a 27B, a 27C motion on this one as well.
Mr. Abbott.
Thank you, Your Honor. I have no objection to dismissing the felony. But as far as witness interference goes, there's no evidence that I've seen. We will look forward to the opportunity to defend the case. Thank you.
Okay, a motion to amend the complaint to an attempted interfering. Is that what
Yes, Your Honor.
is granted? And we'll set this for a date on the misdemeanor docket, okay?
Do you want a final pretrial or do you just want pretrial?
Would you like a final pretrial or do you want another pretrial or a pretrial?
We don't need to.
Final pretrial.
Final pretrial on October 15th. And jury October 22nd.
Final pretrial is gonna be October 15th, 8 a.m. in person at the court. Jury trial, October 22nd, 8 a.m. in person at the court. Any questions? Bond was set, 2,000 personal recognizance. There's a no contact order between you and Veronica Magana. Any additional matters for the record?
Nothing from the people.
Nothing from the defense. Thank you.
We'll get you a notice to appear and you'll be all set. Mr. Frankelson has Robinson.
Yes, Your Honor.
What did you say we were doing with Robinson?
It's gonna be an adjournment, Your Honor.
Bond being addressed. Yeah, we need to very much. Oh, yeah.
Okay, let's see. I need to write an order for that.
No, we've had both flavors. The jail call 1 and the ward was a guy getting aggressively violent.
Yeah, but it's not over yet.
Yeah, no, we can do both here.
Miss Peterson
is what
I don't want keto everything all over again.
What do you mean? You always told me you could take keto.
Yeah, but I was younger than that.
It was only 30 years ago.
Oh,
Oh, but 47-year-old, you had them.
44-year-old,
I
yeah.
printed it off, so you'll.
No, I probably would have given.
You printed over there.
I don't accept you give my age.
I know I just signed one and it wasn't for her. I don't know who it was.
Yeah,
for.
it wasn't for her.
Oh.
Print it again. Or Casey can take them on.
Yeah.
He'll be the champion.
What's for Egleston?
Oh, okay.
Little fashion court notes.
Yeah.
I am shocked I have not had one of those yet.
Yeah.
Hey, I Tyron Thompson tried. He tried rushing around disabled for his court, but the 4 guards around him corrected that decision.
The only one I have for him.
Okay.
Go home and hit the bag every day, just in case.
Correct?
Yeah, hang on. I know. Let me see where we are on that.
Yeah, no, I didn't get one for him.
What time's your appointment at?
Okay, that's fine. I'll just.
Yeah.
Yeah.
I got you.
See the dates on the Bell cases for the senior Mr. Egleston, so that I can make note of.
Yeah, I gave you.
He might be.
No, he's mine.
Yes.
That's the only reason I knew about it.
Maybe I routed them back over.
When I printed that again, did it come off?
Oh, I have his prelim.
That's no,
Oh, no, wait, you're vertical. So
Yeah,
probably
maybe
yours.
that's
When Berkel's on there.
hang on a
it usually
second,
goes
Kelly.
really
Are you out of-
Sometimes it doesn't, but it
Yeah.
usually does.
right.
Just sometimes actually putting your name in as vertical instead of the other spot.
Yeah.
You know, I only wanted to identify. Show up and saying.
Start screening.
It's not gonna run.
Normally it flashes red when it's out.
I'll make sure you guys know.
I thought IT was supposed to be coming to.
Yeah, it's on my computer.
AJ messaged me and said to let him know when you guys are done, so that he can come back. He did come already.
Perfect, thank you.
Yeah, he's supposed to be, do something on my computer in there.
Yeah,
he did.
but I think he needs.
Yeah.
And they said I could. computer needs to be replaced. Okay, here's that.
Thank you.
Thank you.
Sorry. Yeah, sorry. Trying to.
Oh, can I give this to you too? Or do we need to put this in on base? Okay, we'll do it on base. Okay, and this is Robinson.
Yes, Your Honor.
Okay, on the record in the matter of the people of the state of Michigan versus Dante Robinson in 24-01641, appearance, please.
Yes. Yes, good morning. Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Dante Robinson, standing to my right today.
Okay, Mr. Robinson, I do have a preliminary examination scheduled today. A 7-count complaint with habitual offender third offense notice, and we're not proceeding to exam today.
Your Honor, the people will be requesting adjournment for several reasons, and then also bond revocation and jail privilege modification. Because I spoke with the victim today, who told me that she doesn't want to get in trouble, wants to get out of jail, which is not uncommon for my cases. What is uncommon is that while I'm speaking with the victim, she gets a call from the inmate in the jail. And I know because she accidentally picked it up, and it started with the reported message of receiving a call from an inmate in the Ingham County Jail, which I was able to confirm by looking up her phone number from the police report. He called her 4 times this morning, which then let me look into the bigger jail system where he's called her 59 times. So, given that fact, the people need time to have that be investigated. People will also be requesting a P53 hearing. And then on top of that, the officer that I would have testifying under 27C, given that it appears the defendant was likely influencing the victim before her testimony with those calls, is on military leave through the end of October. That being Officer Flesser, I believe. Yeah, Craig Flesser.
Flesser?
Yes. So for those reasons, Your Honor, adjournment is appropriate and necessary. I'm also asking his bond be revoked and that his jail privileges be revoked.
You mean his phone privileges?
Yes. Phone, e-message, video.
You said Officer Flesser is.
He's on military leave through to the end of, I believe it starts September 10th and gone through the end of October is the information that my victim witness unit got. Oh, no, I'm sorry. His leave started today, September 20th. The exact wording that I have is it's on military leave starting September 20th until the end of October.
Counsel.
Your Honor, with regards to the adjournment, I'll leave it to the court, although I do think there could be good cause, but I'll leave that to the court. With regards to the allegations of the phone calls, Your Honor, I haven't heard these calls, so I don't know what the contents of the calls are. You said there were calls made from the Ingham County Jail this morning, but I believe Mr. Robinson was present here in lockup at 54A this morning. With regards to bond, Your Honor, I do believe that current bond would still be appropriate for these allegations. I would demand a hearing before we revoke any bond.
For the record, the reporting is what's played from the lockup as well. And the timing of the calls I found in the lockup match up when I was talking to her. And it's again, her phone number from the police report.
Okay, so again, these are serious allegations we have here. We got a second-degree home invasion, a larceny, and aggravated stalking, firearms by a prohibited person, assault with a dangerous weapon, and felony firearm, and then there's an habitual offender third offense notice.
That might end up being a fourth. I need to go back through. I think there might have been error.
So again, very serious charges to which the court arraigned you originally on and gave you a bond of $125,000 cash surety bond with GPS tether and victim notification. And I advised you that you were not to have contact directly or indirectly with the alleged victim. There's no allegations that there's been contact from the jail 59 times is the allegation. So that would be what we call bond violation. So we refer to them sometimes as PA 53s. Nonetheless, a bond violation is a contempt of court order because you would have been ordered not to make contact directly or indirectly. And so contempt of court is punishable if sustained or with a maximum penalty of 93 days and or up to $7,500 in fines per contempt. And so we'll enter a plea of not guilty on your behalf at this point as to any allegations of a bond violation, because your attorney is going to need to see or get some evidence or some discovery about what is being alleged to have occurred. And then we can decide if we're going to proceed for a hearing on that. But because of the allegations of 59 calls, including the allegation that there were calls very recently, while the prosecutor just so happens to be on the phone with the alleged victim, for your own protection, the court's going to go ahead and grant the request, which is to suspend and revoke your phone privileges, e-message and video, until the time that a hearing is held. That way, we won't have any further allegations of contact between you and the alleged victim. I'm going to also advise you that it would not be advantageous for you to attempt to use another inmate's number to make phone calls. It would not be advantageous. Well, I'm going to restrict your phone privileges, so you won't even be able to have a family member to try to call on your behalf if that was something you thought or would do. I'm sure you wouldn't do that though. And so you will be able to make phone calls to your attorney. However, all of the privileges will be revoked. Bond at 125 cash I think is appropriate. He hasn't been able to post it, I'm assuming.
Correct.
November 8th at 9:30 for both PA 53 and prelim.
So November 8th, around 8:30.
Yes, the court is going to find good cause to go beyond the 21-day timeline due to the officer being on a leave. So November 8th will be the next date for your exam. And we'll have the PA 53 set at that time. There are questions today.
Do we need to address
Mr.
on the
Robinson.
record your continued employment?
Any questions, sir? Any additional matters?
So just one, I know I heard something from Ms. Robinson, he was asking your staff about what it would take to get another attorney, so I'd like to ask Mr. Robinson what he wishes to do.
You don't have anything further? Oh, okay. Okay, well, what it would take to get another attorney is probably you'd have to hire an attorney, because you don't get to pick attorneys out of the public defender's office. They'll appoint an attorney. And unless for some reason you can establish that this attorney is not giving you an effective assistance of counsel, they wouldn't assign you to anyone else. If you believe that to be the case, you can file a motion for that, okay? Do you have any questions? Any additional matters?
No, Your Honor. You will be
Nothing, Your Honor.
prepared.
You're all set.
Thank you, Your Honor.
Thank you, Your Honor. Have a nice day.
Same to you.